To the Finance Number 2 Bill 2024.
Item number 10, श्रीमती निर्मला सीतारमण।
माननीय अध्यक्ष जी, मैं अपने वरिष्ठ सहयोगी श्रीमती निर्मला सीतारमण जी की ओर से प्रस्ताव करता हूं कि भारतीय रिजर्व बैंक अधिनियम 1934, बैंक खारी निवेदनियम अधिनियम 1949, भारतीय स्टेट बैंक अधिनियम 1955, बैंककारी कंपनी उपक्रम का अर्जन और अंतरण अधिनियम 1970, बैंककारी कंपनी उपक्रमों का अर्जन और अंतरण अधिनियम 1980 का और संशोधन करने वाले विधेयक को पुनर्स्थापित करने की अनुमति दी जाए।
श्री मनीष तिवारी जी।
Mr. Speaker, sir, in accordance with Rule 72(2) of the Rules of Procedure and Conduct of Business in the Lok Sabha, I rise to pro forma oppose the introduction of the Banking Laws Amendment Bill 2024, as there is no provision in the Lok Sabha rules to get a clarification with respect to the source of legislative power of the Union Government under the 7th Schedule of the Constitution of India to introduce the proposed bill, even though it may be an amendment to the principal bill. I am aware, Mr. Speaker, sir, that the Banking Regulation Act was amended in 1965 to make it applicable to cooperative societies. I am also aware that it was amended in 2020 to bring cooperative banks under the purview of the Reserve Bank of India, and entry 45 in the union list pertains to banking. However, Mr. Speaker, sir, and this is important, entry 43 of the union list expressly excludes cooperative societies from the legislative remit of the central government and by implication cooperative banks. Entry 44 of the union list does not specifically refer to cooperative societies also. On the other hand, entry 32 of the state list gives specific powers to state governments to legislate on cooperative societies and by derivation on cooperative banks. This matter, Mr. Speaker, sir, it's an important issue of legislative power. If you could indulge me for a second. Mr. Speaker, sir, this matter had also come up when the Joint Parliamentary Committee had deliberated on the multi-state cooperative bill. Now, there are a catena of judgments by various courts in this country, including the Supreme Court, that the power to legislate with regard to cooperative societies and by implication cooperative banks vests with the state governments. Government's answer will be that the earlier two Banking Regulation Amendment Acts have not been challenged. But that does not mean that we can have an ambiguous source of legislative power. So my submission through you, Mr. Speaker, sir, to the government is that where there is ambiguity with regard to legislative power, why would they amend the 7th schedule? List 1, List 2 and List 3, update it so that there is absolute clarity with regard to where government is drawing legislative power in order to enact a particular legislation. Thank you, Mr. Speaker.
मल्टी स्टेट कोऑपरेटिव तो सेंटर के अंदर में आएगी ना? ऐसे में
अध्यक्ष जी, जब जॉइंट पार्लियामेंट्री कमेटी बनी थी इसके ऊपर, ये विषय उसमें भी उठा था, क्योंकि एंट्री 43, 44 यूनियन लिस्ट और एंट्री 32 में विरोधाभास है, और हम लोगों ने उस टाइम पे भी डाइसेंट नोट नहीं दिया था, पर अपनी ऑब्जर्वेशंस दी थी इस चीज के ऊपर कि ये कोऑपरेटिव सोसाइटीज को सेंट्रल गवर्नमेंट रेगुलेट कर सकती है कि नहीं, इसके ऊपर विरोधाभास है। मेरा लिमिटेड पॉइंट ये।
ओके, पर मल्टी स्टेट कोऑपरेटिव का रजिस्ट्रेशन तो सेंट्रल रजिस्ट्रार में होता है ना? मैं पूछना, श्री एन.के. प्रेमचंदन जी, आपका भी नंबर आएगा, आपका नंबर आएगा, आपका भी नंबर आएगा। थोड़ा
थैंक यू वेरी मच मिस्टर स्पीकर सर।
मशीन की तैयारी कर लो आप।
Sir, my objection is not on the legislative competence of the bill. My objection is regarding the rules, practice and procedure, established rules, procedure and practice in the House. Sir, by this Banking Laws Amendment Bill 2024, the government is intending to amend 4 laws. Already the Minister has already said the Reserve Bank of India Act of 1934, Banking Regulation Act of 1949, State Bank of India Act of 1955, and the Banking Companies Act 1970, as well as 1980. There is no legislative, I'm not questioning the legislative competence of these acts, but the problem is compiling or consolidating 4 laws into an one law, that is banking laws. Yes, there are a lot of precedents, it can be done, but it is for the common purpose. It should be for the provisions of all these bills should be interconnected. I will just cite one example. Here, in this case, the Cooperative Societies Act, in which the tenure of the directors of the officers is extended from 8 years to 10 years. It has nothing to do with the original common purpose of the bill. So my point is, this is against the precedents and conventions of the House and the practice which is being followed. Only those provisions which are interconnected, interrelated, and common purpose to be achieved, then only you can consolidate all these legislations together. That is the objection which I would like to raise. Thank you very much, sir.
Sogat Rai ji.
Under Rule 72(1), I oppose the introduction of the bill further to amend several laws. As has been pointed out, this bill is entirely superfluous. It deals with amendment of BR Act to redefine substantial interest. Then again, it changes the rules with regard to directors of cooperative banks. Then again, it goes to State Bank of India Act and says that unclaimed dividends would go to Investor Education and Protection Fund. And then again, State Bank of India Act to provide discretion to public sector banks in the matter of remuneration of auditors. Now, sir, this bill is superfluous in the sense that all that this bill is seeking to achieve can be achieved through administrative steps. If the banks are not reporting to the Reserve Bank of India, then steps can be taken against the bank under the present laws. If the cooperatives, in which there is a lot of corruption throughout the country, are not functioning properly, the banking department can take steps against them. And I totally object to the fact that they are saying that any unclaimed dividend, that it would be go to Investor Education and Protection Fund. So as a result of which, we make complicated resolutions.
Okay.
And sir, Mr. Premchandran has pointed out that in one bill, 4 different laws are sought to be amended. Is this the way legislation should happen in this country? Are there no separate 4 bills are amended in one bill, which is unnecessary, superfluous, and against the interest of the people. Hence, I oppose the introduction of the bill.
Sir, the pointing out of the ambiguity which prevails and also quoting from the slight dichotomy which prevails in the 7th schedule listed items, I just want to highlight, which I think Honorable Member Manish Tiwari also conceded, that there have been several amendments earlier, and probably he felt that it wasn't sufficient to say it's been done earlier, courts have not struck it down, so why not now, would not be sufficient, if I have understood him right. I would think it is important for us to recognize that the ambiguity which he rightly points out between 43 and 45 and 44, 43, 44 and 45, where one excludes the cooperative, 45 which it brings in the banking, and therefore with that done, with that remaining in front of us, the various amendments which have been done to the Banking Regulation Act with respect to the cooperative banks are not just 1 or 2, they are several. 81, 84, 87, 89, 1991, 2004, 2013, and 2020, sir. Just to cite, there are several instances. I don't want to take the Honorable House's valuable time, but the simple understanding is when the cooperatives, we are not touching any aspect of the cooperative other than that which claims under the name of banking. I would not so directly relate it, but I would certainly bring to the notice of this Honorable House. If I remember correct, in 2019, when there was the near collapse or complete collapse of a multi-state cooperative, which Honorable Speaker, remotely you mentioned, multi-state cooperative. Multi-state cooperative bank, not the multi-state cooperative dealing with primary agriculture society. It was through the Banking Regulation Act and also through the insurance, the body which governs insurance compensation to be paid for bank account holders. We had approached this Honorable House and raised the insurance cover from 50,000 to 1 lakh and from 1 lakh to 5 lakhs. And as a result of which we were able to give a lot of small account holders in these cooperative banks some relief. So the interlinkage between banking regulation and that which is cooperative but banks, not the primary agricultural society, is completely getting repeated in history, and every time the Banking Regulation Act has to, with due consideration, to come with a delayed step. This is one of the reasons why not just the Banking Regulation Act, but those related to this, we are doing it at one go. We can always come 4 times to this August House for the same cause. But when it is related to the same function of banks, either under the cooperative society or regularly under the banks, we need to take this route. And that is what is being done here. Just as an example, I'll cite the 2004 amendment, where Section 22A was introduced as a part of the Banking Regulation Amendment and Miscellaneous Provisions Act in 2004. It addresses the validity of banking licenses granted by the Reserve Bank of India to multi-state cooperative societies. Section 22A was enacted to protect the licensing status of multi-state cooperative societies, ensuring that licenses granted before 2004 amendment remain valid and providing a clear process for those whose applications were still pending at that time. So repeatedly, the sections which have been brought in as amendments and also the court verdicts have repeatedly reinforced the point that the Banking Regulation Act and the cooperative banks do have this relationship, and therefore it has to be taken through this route. Otherwise, there is no attempt to undermine the cooperatives, particularly cooperatives dealing with everything other than the banks. Banks, cooperatives with license for banking will have to have a route, and therefore we've shown this. Sir, Professor Saugata Roy, I partly answered him saying why so many acts will have to be dealt with. It is important, sir, that, for instance, the amendment that we're aiming at now is shifting of submission of statutory reports by banks, which he mentioned distinctly, to RBI from reporting Friday to last of fortnight, month or quarter. What's the rationale behind it, sir? The current reporting Friday system has several limitations that impact the accuracy and effectiveness of reporting of the data. These limitations are, and I'll name a few of them: incomplete coverage of monthly data, seasonal fluctuations in banking activities which lead to inconsistent reporting, and the need for adjustment every 11th year, which introduces complications and inconsistencies. And that is why, in order to address this issue, it is proposed to amend the legislation to transition to reporting on 15th and on the last working day of each month. Thereby, accuracy can be brought in. Reports for the 15th would be submitted. Reports for the 15th would be submitted on the 20th of the same month, while reports for the last day would be submitted by the 5th of the following month. So these are largely aimed at a common cause, a point which N.K. Premchandran would say, a point which Manish Tiwari would say, the larger cause is what you should deal with through the acts, but not the minor ones or not specific ones which benefit one section. This is actually going to impact the banking, both of cooperatives and otherwise as well. These are data today which are being used legitimately with approval by very many different sources, and if inaccuracies are going to guide our policy making, it may not be effective, and therefore we had to come up with this. I would seek your indulgence in clearing this, sir.
प्रश्न ये कि विधेयक को पुनर्स्थापित करने की अनुमति प्रदान की जाए। जो सदस्य के पक्ष में हाँ कहें, जो सदस्य विरोध में ना कहें। मेरे विचार में निर्णय हाँ वालों के पक्ष में, हाँ वालों के पक्ष में अनुमति प्रदान की जाती है। माननीय मंत्री जी विधेयक को पुनर्स्थापित करें। आइटम नंबर 11